Chris Marsden, Lilian Edwards, Ian Brown, very warm welcome to Digital Markets Research Hub. Thank you very much for your availability. You were the discoverers of internet law, of several generations of internet law, and you obviously are very impactful authorities in this broader internet law field. How would you highlight to us the main stages of the development of internet regulation?
I wrote down my own taxonomy, which I still tell my students to this day. And yeah, it kind of starts with coming back with Mosaic on a floppy disk in my pocket in 1993, which I take to be the beginning of when anyone knows about the internet, though strictly that's knowing about the web. But I think of internet law as starting in 1996, a bit like Philip Larkin. The internet was invented for lawyers in 1996, because that was, it was famously the Time cover of like, do you know what your children are looking at on the internet? The birth of cyber porn, which became the excuse for regulation for countless decades to follow, as in, will no one think of the children, right? Then various other things happened around about 96, 97. I held my first conference on internet law, so there was enough to talk about. There was the first copyright case, which bizarrely was in Scotland, which I don't even know if you know about, Oles, which was Shetland Times against Shetland News. Yeah. And we all kind of desperately hung out around the Edinburgh Sheriff Court, where they were showing them on a projector what the internet was, because they had no idea. So I think of that as the early days, right? That's the early days, and which largely consisted of taking whatever law you knew and throwing it at the internet. So I put together a course around about that time where I just went round the faculty saying, you teach copyright, can you do something on copyright and the internet? You teach crime, can you do something on cybercrime? And basically that's how I put together my first internet law course, or IT law course as it was called. So that's the beginning. Then I think of, 2000, I don't think this is particularly controversial, as a really cusp point. Because up till then we have this completely disparate set of subjects, really. And round about 2000, at least in my worldview, you get the arrival of intermediary liability, which of course becomes eventually platform regulation. Then sometimes called ISP liability, internet service provider liability. So this is very old times. But round about 2000, you find currents that have been going on about copyright predominantly, but also about liability for pornography, for defamation, for all kinds of things, for the nascent platforms coming into crystallization, right? With notably in America, the Digital Millennium Copyright Act, and in Europe, the e-commerce directive, articles 12 to 15, which really carry a lot of heft for 4 articles. Much like Section 230C of the CDA, which was also 96, I should have said, I think, carried an awful lot of heft for a very, very short section, right? So at that point, I kind of felt I knew what was going on. And then it all falls apart again in my worldview, right? My next book was in 2009, and it's interesting that there's a big gap there because I didn't know what to write about. Because we have the attack on the certainties we thought we had, the safe harbors for platforms, the immunities, the kind of thinking we'd sorted out some things about hyperlinks and copyright, all that sort of stuff. I don't know what was happening with net neutrality, but I have a sense of the disarray of nascent internet law because of the arrival, partly of Web 2.0, again, a phrase you don't hear much nowadays, the interactive web as opposed to the just look at it web. And social media giants. So you have the beginning of the tech giant oligopoly with all the problems that brought, the global colonization, as it were, of the US over Europe. And you have the arrival of the business models, right, of targeted ads, of online behavioral advertising. You get the data mining, you get, data is the new oil. And so everything, and you get P2P file sharing, most notably, I think, for me at the time, which destroyed the consensus we had about, again, the safe harbors and the immunities for platforms and their role, right? So I think that lays the foundations, that period, for the dissensus and the polarization that we've actually seen in internet regulation ever since. And I look back at 2000 as a kind of halcyon point, rather than this mythical internet Wild West that we're meant to have had circa 96. And then I think, and I'll stop after that, then I think for me, the next big landmark is, surprise, the GDPR. Right. So after this long period in the wilderness, as it were, again, we have a kind of striking out, if not for consensus, then at least for a random bag of solutions, perhaps, in the reform of the Data Protection Directive. And it's worth remembering that a huge amount that was in the DPD, which went right back to 95, was still in the GDPR. Yeah. But so I don't want to traduce that. But I think there was an attempt there, if you look at, because I taught it for years, the kind of recitals pre-work from the commission on what it was meant to do. It was meant to combat, the misuse of personal data. It was meant to combat the emergent business models, data surveillance, give users more control, more rights. And then eventually, of course, you get the incorporation, as it were, of Google Spain, which had led to the right to be forgotten even before the GDPR came in. And and then you sort of take it from there. But for me, 2016 to 2018 are another period of trying to create some kind of retrenchment around fairness and principles. And of course, the GDPR has been a very successful export model, and has been exported to pretty much everywhere now except the USA, and of course, some of the USA states have a fairly good carbon copy of it.
Thank you very much, Lilian. I'm sure we will have time to revert to maybe some questions related to GDPR. Ian, what would be your short historiography of the internet regulation?
What I would add is, and I think this is a theme we can keep coming back to, is it's always a danger when people focus too narrowly on very specific topics within what is a very broad field. I mean, as it was famously called in the mid-90s, do we need a law of the horse? A critic said about the idea that there even is internet law, because, and we see this even more clearly now, it touches so many different areas of life and of law. It's a very, very broad notion. And so I've written several review articles. My background is actually more in computer science and to some extent psychology. I'm not a lawyer. I've been fortunate to work with some really good lawyers like Chris and Lilian, and I would mention Dower Korf as well on data protection and privacy law. But I've looked at, some of these debates about governance and policy more broadly in areas like cybersecurity, in areas like privacy and data protection. How far back do they go? I think Lilian's timeframe was great on internet law specifically, but of course, many of the issues that come up within these very specific fields go back many decades. There was a very active public policy debate during the 1960s on what we now call data protection. Actually, the US has the first comprehensive government privacy law from the early 1970s, thanks to that. European nation states had very detailed debates in the 70s. Some of the first German state law and Scandinavian national privacy laws date back to that era. That's why we had the 1980 and 1981 Council of Europe and OECD agreements on privacy. That's what then led into, as Lilian said, the mid-90s, the Data Protection Directive. I did one of the studies for the Commission in the early 2010s on, does the DPD need updating? Do we need a radical new instrument because of all this new technology? And broadly speaking, we said no. And as Lilian said, the GDPR actually contains a lot of the Data Protection Directive. And I think a lot of debate about technology policy and regulation broadly loses sight of all of this history that we have to build on. And I'm sure we'll come back to AI in this conversation. I see this so frequently with AI, and I think a lot of this comes back to, there's so much hype from the companies that are developing it, this wonderful shiny new toy that's going to develop, that's going to fix all our problems. Well, so many of the issues that it raises go back to data protection. Lilian's been publishing on that, for I think at least 10 years, Lilian, on data protection issues and AI. Copyright issues going back to some of the late 90s, early 2000s debates that Lilian was talking about, is training AI on copyright materials fair use or fair dealing. and to a large extent, it is, according to some of our colleagues like Andres Guadamuz, who are still working on this now. So for me, one key thing I want to say is, it's not only competition lawyers that are in a bubble. Many other lawyers and regulators working on technology law, look very narrowly at new technologies and think, oh, all these new issues raised. Well, just look a little sideways, please, because there has been decades of debate about many of them already.
Chris, we know our simplified story in how we try to combat this entrenched dominance or quasi-monopolistic status by all digital gatekeepers who are nascent in this business, who know 1001 behavioral ways to circumvent the spirit of the rules by complying formalistically with the letter of the law. And we try to outperform or to equalize this balance by granting to the enforcers very wide discretionary competences. Can you, what do you think this is the right trajectory of thinking? And maybe you can explain or highlight to us some successful policies in the area of internet law, which can be used as role models, or maybe on the contrary, which can be used as an example of or rather don'ts than do's.
Absolutely. A couple of things to say. The first is, please understand that the problem with the Data Protection Directive of '95 was that it was not enforced, with very few exceptions. And so the GDPR of 2016 is, now we mean it. Now we think we mean it anyway, if we can persuade the Irish and the Luxembourgers to do it. And I think for competition lawyers, it's often hard to understand why it is that so many other areas of law that affect digital networks, because they don't have a centralized or even a well-coordinated system of enforcement, the laws are on the books and they seem to be observed basically in their absence and in companies ignoring them. And so I think that one of the things that we need to be aware of is this fact that we are now enforcing, and that we do actually have serious fines, and also Ian can talk about this more than me, interoperability requirements and other aspects of regulation of these networks to allow market entry to occur. But if we go a little bit back in time, because I had an interesting conversation recently with a US lawyer who said, oh yes, the techlash in Europe dates back to 2016 or 2018 when the GDPR was introduced. And I tried to explain, I've obviously got behind me the cover of the Regulating Code book that Ian and I finished writing in February of 2012. And this was the culmination of 10 years that we've been consulting for the European Commission across numerous projects, explaining why all of that legal settlement that Lilian quite correctly says we arrived at by 2000 or so had not worked. And what we'd seen was the institutionalization of ever larger monopolies, the GAFAM companies like Google and Apple and Amazon and Microsoft and then Facebook. And these companies had grown on the back of the fact that we had laws in place that gave them exemptions from liability, but didn't actually enforce conditions on them to treat consumers fairly, whether it be the Data Protection Directive or many other parts of the law as well. So the tech lash that's supposed to have happened in the late 2010s was actually starting amongst at least European Commission policymakers in about 2003, 2004, where they knew that the 1990s legal settlement that we'd arrived at, which was kind of a copy of the American system, the CDA 230, as Lilian says, and other things, hadn't achieved a proper information society in Europe. And so this techlash is actually much, much older than people realize. I mean, the GDPR itself, as Ian can tell you, but also I did some work with Joel Reidenberg and Scott Marcus and others, where we actually went to places like India, and they said, what laws can we put on the books to pretend to be observing data protection in Europe? This was from the law secretary of the government of India. So they knew that this was being observed in its absence. Right, and that's 2007 I'm talking about. Again, with lots and lots of areas that we looked at, we knew this. And, I published a book, Lilian's allowed me to get this far into the discussion without me saying co-regulation, so let me just say co-regulation. I published a book on co-regulation in 2011, what I believe is these days known by political scientists as meta-regulation. and by some younger lawyers as digital constitutionalism. I'm sure we'll get back to that conversation later on. But this idea that you actually force the company's self-regulatory schemes to conform to human rights standards, to public law standards of reviewability, is something which has been around for 20 years. It's only just now being put into legislation like the Digital Services Act and to some extent the Digital Markets Act. But we've been talking about how much this has been needed for of course, academics are always crying in the wilderness, right? But we've been saying for 20 years how much this is needed. And yeah, the book behind me is our effort 11 years ago to say it. And of course, you know, lots of academics write obscure books that everyone ignores. But you know, it's nice to at least be proven right in the end. And so I think that we need to be really observant of the fact that this is a very, very long turning around of the, well, we could call it the data oil tanker, or indeed we could refer to silk farms. And the way that we've managed to achieve reform has been a 20-year process. And so people should be aware. And that's why I've said, and I think Lilian would have a lot of sympathy with this, if we get the AI Act wrong, then that is another 20-year process towards trying to get it right on the basis of what's happened with e-commerce directive leading up to the Digital Services Act. So these are very, very long processes. And it's been a very long time we've known that it was quite badly broken. As Lilian said, that feeling in the mid-2000s of this is not working out anything like we hoped it would do. It took a very, very long time to actually reform the law to enable us to move to a world where we are enforcing it more strictly. And I will say, I think that it's great that Britain's been thrown itself out of the European Union, because it means that regulation can progress much more rapidly than it would have done if the Brits were still in there. So there's progress at least. Sure.
I think all the things I just scribbled down actually are replies to Chris. So, you know, you wanted a dialogue. Yeah. I think sometimes we overestimate the power of the law. Can I just say that without being shouted at? You know, the failure, as it were, of the 2000 consensus, I think, is that we didn't see that the power of law does not trump the power of business, really, and of business models, right? I mean, what happened was that the business models veered towards data surveillance, you know, surveillance capitalism, whatever you want to call it, which we simply, I think, at that point did not conceive. I mean, as I recall, maybe I'm wrong, the model we had in mind around about 2000 was mostly ISPs that charged so much per month or so much per minute or so much per megabyte and gave you 20 megs or 20K, I can't remember, of storage space on a server somewhere, you know, the very, very, very early cloud. It was not the freebie world, right? Was there any free sites on the internet around that point? Probably, but and that all happened in the early 2000s, yeah, with Google and Facebook. So we just didn't see the way the wind was blowing, but I'm not sure that we could have, right? So I'm not sure that was a failure of the legislators, as it were. You know, where it obviously connects up, and you can't divide this stuff up, I'm sure regulatory theorists do, but I'm not one of them. Where it connects up is governments always want to, you know, grow the economy. Therefore, they want basically to favor capitalism. They want to favor the creation of, you know, goods and services by companies, and that leads them towards a kind of laissez-faire capitalism with a lack of political will for strong regulation. I mean, that's been the picture of the last, 20 years, at least in the UK and the US. And that's why, very, very unlike Chris, I was quite surprised to hear that, I'm extremely sad that we left the European Union, not just for myself, not now having the right to get a cushy job in Barcelona, but unlike Ian, but failing to be able to get in on the goodie bag, really, of the only regional bloc in the world that seems to have the guts or, you know, the savvy, because it's fighting the tech oligopoly in the US, to regulate in a coherent and relatively strong-willed fashion, right? You know, and we are drowning right now, of course, in the EU digital acquis. You know, I mean, I kept up as far as you know, the DSA pretty much, and not so much the DMA, and then very much not the DGA, the DA, and I think you laughed before, all as the Fish and Chips Act and so forth, all of those ones. But at least they are trying. At least they're not just going pro-innovation. Let's do nothing and hope that people will come and set up their branches with us and treat us like slaves, but that'll be fine. We'll be the new Singapore, you know, and then we'll just worry about existential risk. That's essentially the UK narrative right now. And I have to say, I find it profoundly depressing. And that's why I will never get a seat in the House of Lords. So I think we're talking about, you know, as a not just regulatory power and certainly not just regulatory discretion. I think the FTC shows that wide discretion can be used very, very effectively, actually. You know, one of the many interesting, weird things that are going on right now is that, you know, Europe prides itself on having created, you know, human rights-based strong regulation as opposed to this laissez-faire capitalism stuff. And yet it's the US, again, without a strong tradition of consumer law, that's steaming ahead. You know, I mean, the FTC, using its very, very wide and vague power, is the first place that's really going for algorithm deletion, you know, for model deletion as a remedy, which Europe does not really seem to have got its head around at all. So they call it algorithmic disgorgement, which makes me feel slightly nauseous. But it is quite strange that the country, of light touch regulation and poor consumerism preferences is now really leading the pack, you know, and I think a day ago, you know, we have all the states in the US, more or less, are suing Meta and Instagram, you know, as a subset of Meta, for destroying our children, or maybe your children. I don't know. They're not mine, and that struck me as absolutely remarkable regulatory development. Chris Reed, who is another, you know, major doyen of the field, who perhaps doesn't get mentioned as much as he should, perhaps because he goes to fewer conferences abroad, I think, than us three. Sorry. He did a rather good book whose name I forget right now. I dug it out yesterday, where he tried to apply kind of regulatory theory to his very long-standing, decades-old knowledge of down-to-earth, really commercial internet law. And he identifies, and I agree, that the two great failures, actually, I think, of internet regulation in my time have been digital signatures, which no one really thinks about very much, and which we all wasted a great deal of time on teaching to our students who looked extravagantly bored, and, you know, have either settled into the software and no one pays any attention, as in kind of banking software or whatever, or have been, you know, we've discovered we don't need them and we can just go on using really terrible passwords, right? And now we have new technologies hopefully coming in to replace passwords, but then they're not digital signatures. So that was a complete waste of time. And, you know, again, I think that was perhaps too slavishly trying to translate really a kind of continental model, perhaps of notarization, I think, into the digital world. Because I was told by an Italian once, I don't know if this is true, you know, that whereas you always say in Anglo-American law, you know, that everything is permitted until it's forbidden, that with them, everything was forbidden until it was permitted. So they couldn't do anything on the internet until somebody said, this is okay, we've passed a digital signature law, which again seemed very perplexing to me at the time as a young common lawyer. And the other big fail, I would say, was e-money, at least in the original form, where again, you have a slavish idea of trying to reproduce the features of cash, really, in digital form, you know, so Mondex, who remembers that, you know, as opposed to what we really got, which was PayPal, you know, and then all the subsequent electronic wallets and so forth, which is the same old money delivered in convenient ways over the internet. And that's what actually took off, right? And, you know, I'm sure, obviously, I'm not going to go on to Bitcoin and so forth. There's no time and it's too boring. And stupid and all these things. I've just read actually Michael Veal's new syllabus, in which I think he describes it as something like an over-engineered Ponzi scheme. And I think that's quite a good summary. Yeah, and I suppose for what it's worth, my example of regulation that works is the GDPR. Obviously enforcement is tough. Enforcement requires money and political will, right? Some countries have got one, some countries have got, I don't know if does any country have both? Maybe Germany, maybe some of the German Länder. But it's a rare combo, right? But as a piece of law, and in other areas of law, like, contract law or property law or something like that, we wouldn't go on so much about enforcement. We would probably just look at the law on the books. As a piece of legislation, I think it covers a hell of a lot of ground in a relatively clear way. And although we are getting quite a lot of case law on it now through the CJEU, there's been no huge failure, I think, of understanding in it. What there has been, again, is the world has changed in ways that perhaps we should have predicted this time. So you've got the crisis, which Nadia Pertova has aptly named, which is the law of everything. The fact that when the world becomes primarily mediated through digital environment, data protection by default has become the law of everything. And, the regulators naturally cannot cope with that, even if there was the political will and the money. So, but otherwise, as a piece of actual principled, worked out schematic legislation, I think it's a success. So.
Thank you very much, Lilian. It's funny that we had a few minutes ago a conversation with Ian, and he almost verbatim repeated your skepticism about some areas of law. So, Ian, how do you see the successes and failures which we can learn in while trying to relate in competition in digital markets?
Well, briefly, again, agreeing with what Chris and Lilian said, the GDPR was, Lilian was commenting on it, I think, mainly from a legal perspective. I would say also from a geopolitical perspective, the GDPR has been such a success. It's trumpeted these days. I think the author is Anu Bradford, as the sort of the Brussels effect, the EU successfully exporting its regulatory framework to the world, and our colleague Graham Greenleaf in Sydney faithfully tracks data protection laws around the world, and I think including the European Economic Area, there are now over 160 states that have GDPR-like comprehensive public and private sector horizontal data protection law. So that's been a huge success. As Chris and Lilian said, problems in particular with, I think, big tech companies and Ireland, taking advantage of each other to have lax enforcement coming out of Dublin. That is about to change. I think Ireland is in the process of appointing 3 new data protection commissioners. Max Schrems has applied. I mean, that would be very interesting if he was appointed as one of the 3. But of course, in the DMA and DSA, the EU has learnt from that particular regulatory failure of the GDPR of trying to leave things decentralized. Of course, it's an eternal tension in EU policy making. The balance between central and national enforcement and decision making. But I think, and to be fair to the people that negotiated the GDPR in the mid-2010s, it wasn't quite so clear then as it is now that we have these gigantic trillion-dollar big tech companies bestriding the globe. And clearly, with the best will in the world, even if Max Schrems had been the Irish Data Protection Commissioner for the last 10 years, I'm not sure much would have turned out differently. You need continental scale groupings like the EU and like the US and the FTC to effectively regulate businesses of that size, I think. And it's a reminder why the original antitrust laws in the States of the late 19th century were absolutely right to say this is as much about democracy and preventing regulatory and political capture as it is about narrow consumer welfare standards. And I'm glad that we are returning to that. On the out and out failures, Bitcoin, cryptocurrency, crypto assets more broadly, the metaverse, digital signatures is a great one, Lilian. I'd almost forgotten about that, but it's the emperor that has no clothes. And I hope, generally speaking, this is something I, as more of with a background in computer science and a strong interest in behavioral economics and economics more broadly, can bring to some of these debates to be able to say, I did, this is not just with the benefit of hindsight that the 3 of us are saying these things. I said, I published an article in the late 90s saying digital, all of this digital signature law is just largely a waste of time. And indeed, that is how it's turned out. I'm glad that blockchain and cryptocurrencies to some degree have already exploded, imploded, I should say, before we all waste our time with, global blockchain treaties and legislation. It's clear now. I think that would be a waste of time. That the metaverse is a hilarious joke, although not for Meta's shareholders who see their $10 billion a year going up in smoke on that. So I think that's one, trying to draw a broad point here. That's why having technologists involved in internet law and regulation and politics debates is important, because sometimes I quite understand why people who aren't technologists might have fallen for the marketing guff of these various technologies. It's really quite obvious if you if you look just for with a little bit of care at some of these technologies and understand that really they don't have use cases. Lilian's payment example is a really good one. Visa and MasterCard work really effectively, on a global scale. They clear transactions really quickly. They are not perfect. We have mechanisms for dealing with some of the problems of that approach, not least competition law and payment regulation. So I think, that's a great example of saying, okay, this existing approach may seem slightly old-fashioned to people that have not looked at these laws or how they work in practice, but actually let's fix those. We don't need a whole new set of laws about many of these technologies.
Thank you very much, Ian. Thank you very much for this. I wanted now to maybe to revert to your main research topics which currently preoccupy your interests, because obviously you three are trendsetters in many respects. So maybe by learning more about your current research, ongoing research, we will basically can infer the relevance and topicality and try to combine our own future plans with this areas. Chris.
Yeah, so a couple of thoughts. And by the way, Lilian, you're quite right that Brexit was a disaster for Britain. And I personally was so annoyed, I moved to Australia. So I think I may have been one of the more violent reactions to Brexit that occurred. And I'm only half kidding. I mean, there's lots of reasons why I moved, but one of them was that I just could not live in a country that was where the government was so unbelievably stupid. And that maybe brings me to one of my three areas that I'm researching. And so one area I'm researching is comparative regulation of artificial intelligence. And I know that you're all looking forward to the Bletchley Summit, which is now coming up, which is apparently going to be, there was an extraordinary tweet from the Department of Business in the UK that this was an epochal moment in our technological history, which probably makes us all feel nauseated, not just Lilian, when we think about that. So comparative regulation of AI is extraordinarily important. And this is a game where it's really important to be very aware of, as Ian said, the kind of snake oil salespeople of technological untruths. And there's a lot of them out there, in particular the people who seem to have read American Prometheus and watched Oppenheimer and decided that they can sell that to the governments of the world, and the gullible presidents and prime ministers are buying it, which is sad. So I think AI comparative regulation is extremely important. And I think it's really important that we don't let some academics start comparing the United States and Europe, where there's a valid comparison about what do we do about speech content, because after all, we are talking about speech content on the internet and in many of the models that are produced by AI, with a regime which is completely incompatible. So I vehemently disagree that we should compare China to Europe or the United States. And to say we can take lessons from their speech laws is an absurdity and actually an obscenity. So that's just a word from somebody who actually sits in Australia looking up at Asia, knowing that we really don't have anything to learn, other than the fact that far too many parts of the world are willing to reject what in the 90s we called this Washington consensus, but the kind of American-European consensus about free markets to some extent regulated, whether it be by the Fair Trade Commission and, as Lilian said, the Very Wide Commerce Act and Sherman and Clayton Acts and so on. The rejection of that by so many parts of the world means that they say, well, we were quite interested in the Chinese model. I want to be clear, the Chinese model is the rejection of multi-party democracy. And their speech models are the same thing. And that maybe brings me to my second part of my research, which is looking specifically at disinformation and the regulation of particularly AI-generated disinformation. We're moving into a year next year, all your students will be aware when they read this, when they listen to this conversation, that next year there are incredibly important elections for the European Parliament, for the Indian government, for the United States government, for many national governments, probably not the UK, because I suspect that your government will hang on till the bitter end in 2025. But there are huge numbers of people, over 2 billion people in functioning democracies going to the polls. And it will be a far more computer mediated election than what we've had before. And Ian and I, together with Michael Veal and others, we wrote a report for the Commonwealth more than 3 years ago now, Ian, 3.5 years ago, where we did warn them how much we needed to invest in defending and securing our democratic systems. Here in Australia, we've just lived through a referendum campaign where one side of the referendum campaign achieved a spectacular hyper-normalization of lies and of untruths beyond the dreams of what was achieved in 2016 in the Brexit campaign. And I fear that this is where we're going in 2024 with whatever is inflicted on not just the United States, but also I think very much the election system in India. So that's the second. And then the third, which I think Ian could talk about more than me now, is that I've been exploring this co-regulation of the internet, which has been instituted by the Digital Services Act. Some people call it digital constitutionalism, but certainly it's co-regulation. It's government overseeing the regulatory systems that companies are arriving at, making sure that there are proper audits and so on. And one of the important things there is that Ian and I did a piece of work actually for colleagues of ours in Tokyo in Japan, where we looked at app stores and we explored what was maybe the most explicit example for your students. They will know all about this. They are regulated when they use their phones by, if they're poor like me, by the Android system and therefore by the Google Play Store. And if they're rich like most of my students and are using iPhones, by the Apple Store. And they know that these are their regulators. And the extraordinary thing that we discovered when we were doing this research, or reminded ourselves, because we've talked about this for at least 15 years, Ian and I, in fact, a geeky presentation in 2008, Lilian, where we talked about some of these things, is that if we do not regulate effectively these monopolists, we are simply allowing the Googles and Apples and Amazons to take these very, very supernormal profits from the companies that have no choice but to work within their ecosystem. So that's the kind of the third piece of work. And I think it very much relates to a lot of the work we did more than 10 years ago, talking about interoperability as a solution. Because if we can't get new platforms into this space, we are left with decades to come of the Googles and Apples and Amazons and Facebooks taking their gigantic rents from any company that wants to play in the public internet space. And that would be a tragedy. And it should be said, of course, it's these companies that have the largest research budgets and are going to be the most important and dominant players in AI as well.
Thank you very much, Chris. Lilian, what is your the top of priorities at your table?
Well, top of my table, predictably right now, is AI regulation, which is what I've been spending most of the time doing for the last 2 years, maybe. I increasingly find that all my areas of research seem to tie themselves together into a sort of twisty, knobbly thing, you know, and I find it quite hard increasingly. It was so much easier, you know, like one week you taught cybercrime, the next week you taught data protection, and the week after you taught, I don't know, net neutrality. And it never seems to be like that anymore. It only ever seems to be like one or two problems, you know. So in the same way that I used to teach a whole bunch of subjects, I think you could now say, and again, it was quite interesting looking at Michael's syllabus yesterday, that aside from like topping and tailing it really with like a, you know, one lecture on governance maybe and one lecture at the end on something wacky, you know, there only really are two games in town. You know, they are regulating data and particularly personal data, and they are regulating large platforms, you know, which obviously ties intimately to the previous, right? So for me, at least the idea of transferring everything I'd learned, because I've been working with AI, with rule-based expert systems since 1985. I mean, you know, cut my head off and count the rings, I usually say. To at least look even vaguely at a fresh new area was very enticing. And of course you do get there, as Chris has just said, and discover it's the same old game. You know, apparently there's actually been more lobbying by the tech giants, who this time include Microsoft as well as Facebook and Google, for the AIA than there has been even for the GDPR, which we previously thought was the all-time, you know, perennial winner. So yeah, I've been working on that, you know, the nuts and bolts. I'm originally a private lawyer. I'm not a theorist, so I tend to just want to understand how things work and solve problems with them. But that has led to, I suppose, what you might regard as slightly more theoretical work around the governance of generative AI, which I also find interesting, partly because, again, it has very important implications across such a wide range of fields that I feel I know something about, you know. So it affects copyright, it affects the creative industries, it involves deep fakes, which affect both, again, actors, the creative industries, and also gets you into the realm of non-consensual sexual images and so forth, what used to be called revenge porn. And I've worked in all of these for ages, she says scientifically. I think I was in Florida teaching when the first sort of deep fake scandal hit, actually, because it was a website that was put up by some bastard in Florida, right? Which was called something like Is It Up or Is It Down? Can't remember, there were two of them. So that interests me. I'm always keen on looking at phenomena that kind of have impact across various legal tools, various legal regimes. I mean, that's why I got interested in intermediary liability so much back in 1999, because I could see that it was going to be the kind of golden thread that worked on the laws that we were looking at separately at that point about porn and copyright and so forth. So what I've got onto most recently that I'm getting mildly obsessed with, and which actually ties quite nicely to some of the comments that were made earlier about the kind of human rightsification of private companies, you know, and these various passing mentions of digital constitutionalism, which maybe we can come back to. I'm quite interested in models of governance of generative AI, starting with whether it does need anything new, you know, particularly taking Ian's point about how you have to always be aware of what the technology is doing, right? But not in a techno-deterministic way. But it looks like, you know, there's quite a high chance that in 5 years, we may not have large general foundation models. You know, all the money seems to be going to, you know, we'll have that and then maybe we'll forget them and we'll train specialized small models for all kinds of reasons. So we may end up back at non-general purpose AI, you know, to adopt the EU approach. But if you do assume that generative AI goes on being important, which is, you know, what all the hype is, then, you know, how do you regulate it? So I am back at these very basic questions right now, as with Chris Reed and Julia Black and all these people, and I'm ordering books on regulation. So the little project I did earlier this year, having, as I say, thought quite a lot about how do you apply existing law to regulate AI. So notably copyright and the GDPR, and notably Article 22 of the GDPR, on which I've written quite a lot. Then how do you regulate it with bespoke legislation, of which obviously the EU AI Act is the dominant example that, again, wants to be a global model. But yeah, the Chinese model is interesting. And I think, you know, passe, I totally agree with what Chris said. But if you can say, and you have to give it all the caveats, and I always do, you know, this is not what China is really doing. China is not trying to regulate AI in a vacuum. It's not trying to help its consumers. or its citizens. It's trying to protect the state against its homegrown tech industry because it's worried that they know more, they have more data about people in China now than the state does, and they're worried that it's a good way of manufacturing anti-state propaganda or disinformation or whatever, and therefore it might evade the Chinese firewall, etc. So they have their own very strong political goals in there that have to be kept in mind. But if you took all that aside, which is a big aside, there actually are some really interesting, statements in the Chinese law. And I'm going to talk a little bit about this, I think, in Australia, maybe not in Melbourne, but we'll see. So there's all that. So I feel I've spent about 2 years or a year and a half going through that process, or at least since 2016, if you like, about how do you apply the GDPR to AI. And what I'm now looking at is private ordering, is this idea of how do these companies regulate themselves through their terms and conditions, through their privacy policies, through their licenses, through their codes of conduct, and there's this great phrase which seems to have been forgotten, that back in the days of eBay, and again, I remember teaching a whole class on the law of eBay, that they had shadow legal systems. They had so many kind of instruments attached around them. And OpenAI, if you look at it, was looking very like that a few months ago. I think perhaps they've streamlined it a little now. It's amazing how fast the terms and conditions on these sites actually change. Not so much Google, because they rolled it in with their ordinary terms and conditions and added a bit, but the other ones, the Mid-Journeys, the Stabilities, the OpenAIs, etc. And that is very interesting stuff to look at, just to see, what's in there, what isn't in there, what's ignored, what does it say about content, what does it say about privacy, what does it say about copyright. So at a very basic level, I think my intuition, which I think has proven to be right, is that there's been a cottage industry in North America, of examining the terms and conditions of what we used to call social media giants, or platforms, because it was all they had to some extent, because they didn't have a functioning data protection regulation. All they could try and do was look at the terms and conditions and try and give more transparency, try and do a bit of like validation, as in, does it comply with other types of law you have lying around, try and get the FTC involved and so forth. So it was kind of the best game in town. I think no one was doing that work for generative AI, maybe partly because we have the GDPR, but there's a lot more going on than the GDPR. So anyway, I think you do need to do that work, to look at both for transparency, for activism, for compliance, and to see where the way the trends are going. And my intuition, which is my new thing, is that the generative AI providers are trying to set themselves up as the new platforms. Right? Because this gives them still quite strong vestiges of the safe harbor immunity model. But they aren't platforms. They're not intermediary services. They make their own content, right? The user just puts in a prompt. That's a very small part of the affair, right? They don't fit any of the definitions, and this is where it gets interesting. They don't fit any of the definitions of a host or an intermediary service in the DSA. So at the moment, they have absolute cake and eat it, right? Because they can deny everything, really, in their terms and conditions, which is pretty much what we and now Natalie Hellberger and her team have discovered. And they're not being regulated by the DSA. So this is a very interesting place to be, I think, as we head into the next generation of AI. Haha. Generative AI is the next generation of AI. I didn't mean that. And so that's what I'm working on right now.
Thank you very much, Lilian. It was really, really insightful. Ian.
Like Lilian, and I think Chris to a large degree as well, I'm interested in solving practical problems. I actually, until about 2 years ago, had tried to stay away from AI because, first of all, I think that the term itself is misleading. From my psychology background, these are not artificially intelligent entities in any meaningful sense. in the way psychology uses the term intelligence. And I think it's, that's not just a pedantic or academic point. It's really misleading to policymakers and people thinking about regulation. Chris and I heard this so often when in the past we've been writing about disinformation. Policymakers, from even 5 or 6 or 7 years ago would say, okay, social media platforms, your content moderation regimes in practice are terrible. They're letting through all of this problematic content. You need more AI. Invest in AI, basically, because it will magically solve all of these difficult freedom of expression issues. And of course, that's complete nonsense. The idea that these technologies today or then or any time in the foreseeable future will be able to deal with the nuances of human rights law around freedom of expression and around other types of law. Even just spotting satire is something that can be difficult for humans to do. Never mind for these very large scale statistical appliances, as one of our colleagues, Derek Macaulay, I think rightly calls them. But I've been sucked in. It's inescapable. The hype has absolutely taken over. I don't think, unlike blockchain and unlike the metaverse, that there's nothing there. I think there's a lot there. I think AI will, whether it's a general purpose technology as broad as the computer or as broad as the internet, I think we will see over time. But clearly, it's going to be significant and important going forward. And as Lilian and Chris both said, it brings in many existing areas of work that we and many others have been looking at for decades. So it's a great way to sort of reapply some old lessons, but update them and integrate them with other areas of technology and other areas of law. And in particular, all of these new competition tools. One of the very specific projects I want to work on in the next year is, okay, we have the DMA. How far do those provisions apply to generative / general purpose / foundation AI models? Is OpenAI a gatekeeper of the future in DMA terms, or is the DMA drawn too narrowly to cover that? Will the UK's more flexible planned model, as equally skeptical as I am of Brexit as Chris and Lilian, it will be interesting to see if taking a slightly different approach as the UK does will have an effect. I think I've learned a lot having had more time over the last 3 or 4 years to look at digital competition economics. I think 2 really interesting things competition brings to this broader internet law and regulation debate, a sort of a very clear-eyed economic focus on what are the structural reasons that platforms have risen over the last 20 years and come to so dominate the environment. We know now some of them are actually relatively straightforward things, like the extreme returns to scale and scope of many digital services, the importance of data, the importance of network effects. We know from competition law and economics broadly, and particularly telecom competition law and economics, we already know some remedies for some of these issues, whether that's interoperability mandates as the DMA has, whether that's requirements for data access and data sharing as the Data Act has. That's agreed now. It's not even on the statute book yet. So I'm really interested to see how can we use these new tools alongside existing tools like the GDPR to deal with some of the issues that AI and particularly generative / general purpose AI will bring up. And then finally, I would say an ongoing interest of mine, linking again to what Chris and Lilian said, we don't think everything the same, but I think we are 3 like minds, and that's one reason we've enjoyed working together for many years, is not just the relevance, because clearly human rights remain as important as ever, and even though they are 70 years old, which is generations and generations in internet law terms, the importance of human rights remains the same. How do we ensure the effective protection of human rights when private actors are so powerful and so important in these ecosystems, whether that's through, as Chris was saying, through co-regulation, whether it's through specific law and regulation like the Data Protection Act, like human rights enforcement cases. I was very involved in the 2010s with what led up to and then happened after the Snowden revelations, the extent to which democracies like the US and many European countries had instituted without any public and democratic consent these regimes of mass surveillance. And the European Court of Human Rights ultimately was unhappy with aspects of that, not with all of it, but I was an expert witness in Big Brother Watch and others versus the United Kingdom in Strasbourg, and the Court of Human Rights did say the UK's regime goes too far. It's not compatible with Article 8, the right to privacy of the European Convention on Human Rights. So how we translate those concerns for human rights into effective shaping of these new AI-based systems, I think it is and will remain very important.
Thank you, Ian. Let me move the direction of our conversation, of last part of our conversation, to the issue which has been mentioned in passing, Brussels effect. Anu Bradford, her new book, Digital Empires. She puts forward three main empires: state-driven Chinese model, US-driven market-driven US model, and human rights-driven European model, let's say EU, UK, European model. So I wonder, do you think it's for the future of the digital economy and digital society of Europe, is it enough to be just human right, to be a kind of moral imperative, moral polar star which would navigate the entire globe? Or do we have to be preoccupied with building up and scaling up our own digital infrastructure? And if yes, is it even feasible? What is the future of UK and EU in this global digital race? Is it a zero-sum game? Should we just should we try to have our stakes in beyond regulation in technology itself? Is it feasible? So this kind of what do you think about this kind of geo-economic or societal matters, Chris?
First thing is, by the way, I would never be brave enough to write a book about countries where I didn't understand the language. So I really do admire Anu for that. But I do think that we are, in a way, going back to the early 1990s. There was a book written by Lester Thurow about the varieties of capitalism and the three-cornered fight between the United States, the European Union, and Japan, in which he said that ordoliberal Europe would win over the other two because of its ability to meld together the flexibility of Japanese capitalism with the robustness of American. Of course, it's all nonsense. So here's the two things I think. The first is, by the way, there is no Brussels effect. It's a Strasbourg effect. Brussels is part of it, but other countries around the world, as Ian said, Graham's now counted up to, I feel like there should be a kind of Times Square type of sign about how many countries have got Data Privacy Act. It's now up to over 170. Of course, how many of those are enforcing it is probably in the 20s, certainly not including Ireland or Luxembourg properly yet, to take a couple of examples. So yes, there is this Strasbourg effect, which is very important, which is about how do we apply human rights. I think there's a major danger, which is that Europe comes across as enormously sanctimonious to all of our trading partners. And it's not helped by this extraordinary language used about the AI Act, which it almost sounds revivalist the way the European Commission talks about it, because this is an act which was designed to do the bare minimum in order to assert German or French attempts to regulate more strictly, or possibly Belgian attempts as well, AI. So, you know, the idea this is somehow our standard banner is just nonsense. But nevertheless, nonsense which the European Parliament is still continuing to speak as we go up to the election. There is a great danger, as Lilian, I'm sure, would agree, which is that there is going to be an AI Act agreed before the European parliamentary elections, because far too many MEPs have spent far too long talking about it, and they want to have a win before the European election actually happens. So I think that we really shouldn't be worried about things in quite these terms. I do think that there is a long-term European problem when it comes to domestic, this ridiculous term, unicorn companies, you know, these billion-dollar companies, mainly born out of the fact that European engineers often find it, from a selfish point of view, much more much greater monetary advantage to work in the United States or other parts of the world where the tax regime is much more appropriate. If you don't believe me, go to Gibraltar and see how many people are working in software development in Gibraltar in order to take advantage of their lower tax regime compared to other countries, or which will equally say Ireland, Luxembourg, Cyprus. And when it comes to how much there is a European model, I think that, again, we overestimate the extent to which there is a single European model. And I and Lilian and others were reminded, anytime I go to Iceland, I'm reminded that there are countries that are really genuinely interested in human rights and multi-party democracy and free speech. And then there are the rest of us. And I think that it's worth bearing in mind that the impact of European law in the digital space, as in many other spaces, is very uneven between members of the wider European community, not just the EU and the UK, but the wider Council of Europe membership. So I'm not sure if there is one model, and if there is one model, I'd say it's effectively Strasbourg dominated. And by the way, Ola, just for the benefit of your students, the great success, I was saying, of European law in the digital era was actually about the liberalization of telecoms and the achievement of affordable broadband. And there was a strong risk that would not have occurred in the 1990s, without which all of the things we've been talking about in the last 20 years would have been happening via, dial-up or technologies of much lesser capacity than what we've actually achieved, albeit that we could have achieved much more than we have done. So the success was European telecom regulation based on essential facilities, which your students will be familiar with.
Thank you very much, Chris. And are you equally skeptical about the need to develop or the importance of digital infrastructure in our kind of strategic development as political entity, so to say? Is it something that's just a hype, or it becomes critical, and thus we have to consider it as a shortcoming, not having a control maybe, or a domicile of some medium or large tech companies within UK or EU, or is it something which is more related to kind of to just colorful discussions with no significant impact on the development of digital society?
Yes, I mean, I am dismayed at what a supposedly technocratic, just get things done Prime Minister Rishi Sunak has turned this, AI carnival next week in the UK into. I mean, I should say I worked for a year and a half as a civil servant trying to improve the use of scientific evidence in digital policy making in the UK government, and I gave up. I left because it was really having so little impact. And I didn't see anything quite as catastrophically bad as this AI Safety Summit next week, but I really saw that it's the nature of democracy. Ministers aren't that interested in evidence or what experts think they should do. Sometimes that's correct. I mean, we live in democracies, not technocracies. I wouldn't want to be Prime Minister. I'm sure Lilian and Chris would make wonderful presidents. But having said all of that, I think one thing is Europeans, you frequently hear this, all of these European laws and regulations will become irrelevant over time because the US is where all the innovation is happening, and even more importantly, where all the revenues are flowing to. That's always one of the arguments, going back to Chris's mention of fair share and net neutrality. It's one of the key arguments that European telcos make. Effectively, they want a GAFAM tax. And they say to European policymakers, look, can you hear that fucking sound? It's European revenues flowing across the Atlantic to California. That in a sentence is the argument that European telcos use repeatedly to try to, I think wrongly, for many reasons we don't have time to discuss today, but read Chris's books on net neutrality, try to argue for. I did a study for the European Parliament with colleagues on the nascent cloud computing industry in about 10 years ago, when we interviewed lots of stakeholders, business and other stakeholders. One of the key findings of that study was the EU should not necessarily be concerned that it doesn't have homegrown cloud hyperscalers. most of the economic benefits from the cloud come from other businesses using cloud functionality, not companies building global clouds like Microsoft and Amazon and Google in particular. And I think, there's something to be said for many different areas of technology here. Europe doesn't have to be at the bleeding edge. Europe doesn't need to have the world's biggest technology companies to still have a very significant impact and to do positive things for European citizens and European societies, which is why policymakers are there in the end. I think a really good example I've heard from Chris in the past, actually, sorry for stealing it here, Chris, is if you look at Linux, which comes from a Finnish undergraduate computer scientist initially, and then it grew as an open source project with input from many European and American and other businesses. Much of the benefit of Linux has gone to society as a whole, rather than being captured narrowly by a tech titan. And we always have to bear that in mind. Yes, it is impressive that the 7 largest companies in the S&P 500 in the US are worth $8 or $9 trillion last time I looked. But of course, there are many, many broader benefits of technology which you don't want to accrue to these giant companies. I think it's critical for not just the future of innovation, but the future of democracy, that we don't have these gargantuan businesses that become almost, as powerful as not just minor nation states, as medium-sized nation states. I think that's a very damaging long-term outcome. I'm glad the current US administration, in great contrast to going back to Reagan, is fighting hard on competition enforcement. And let's just hope, for the sake of democracy and liberalism around the world, that approach continues, rather than the potential alternatives in the next US presidential election.
Thank you very much, Ian, for this. So we have left time for our traditional recommendations for students. So if I may ask each of you to share with our undergraduate, maybe postgraduate students, some recommendations, some suggestions, some do's and don'ts, which in your view these days are of particular relevance. Chris.
So I would say 3 things, and Lilian's quite right. It's 11 o'clock at night, so if these don't come across as perfect recommendations, you'll understand why. It's much later here than it is where you are. So the 3 are: first of all, learn from the history. There are so many lessons from the history of digital technology that we can apply going forwards to AI, to cloud, to blockchain, to many other things. And for your students specifically, I would say they should read the work of Herbert Ungerer. Ungerer was in GG competition in the late 1990s, worked on the development of the essential facilities doctrine alongside John Temple Lang. Several speeches of his on the DG competition website now. You can still find them on Europa, albeit that Europa keeps trying to change the links, so it's very difficult to continue to find them. Their regard for history is less than ours. And they should be very aware of the development of the essential facilities doctrine, what that means for where we are today. Second piece of advice for them is that they should follow these gigantic businesses that Ian described so well, and think about why are they valued at $1 trillion. And they're valued at that because the assumption for the investors is that they are durable super monopolies, right? That's why they're valued so highly. It's not because of what they do, it's because of the assumption of them getting many, many years of enormous rents in future from their domination of the tech industry. So they should think about that. And I would suggest they should look at the SEC filings of these companies. There's always a fascinating couple of pages on regulatory risk, and they should look at those to be able to see what the companies are scared about going forwards. So they will talk about data protection. They will talk about issues like competition law problems emerging. And I think the third thing your students should look at is the extent to which this is damaging us as a democracy. The reason why we have competition law, the reason why we have consumer law, is to protect our citizens, the individuals in our society, and indeed the collective society, from the evils of monopoly. And this is something which we developed in the 19th century, we developed more through the 20th century. The entire German ordo-liberal tradition, of course, talks about the dangers of what happens when you have these massive conglomerates. One of the causes of the First and Second World Wars, was the driving of very aggressive industrial policies by empires, which then became open warfare. So they should be aware of the fact that what happens in digital competition really affects the future of our societies and the potential for us to have a peaceful and prosperous future. And that's why I look at disinformation. And it's why your students should be very aware that these trillion-dollar companies do not have the same interests that we do.
Thank you very much, Chris, for this. Lilian.
I wasn't sure if recommendations meant recommendations for, like, you know, think about the history, or recommendations for like books or articles. So can I have a sort of a mixture? This is like Desert Island Discs. Okay. Desert Island Internet Law. I think I always feel that either I'm just the most devil's advocate of my friends, which is probably not true, or the least woke of my friends, which might be true. And every time that I'm in conversations with people like you guys and so forth, there is this little voice at the back of my head that goes like, well, you know, there is a reason why people use things like Facebook and Twitter, even though they're owned by megalomaniacs and are destroying democracy. And that's because they're really convenient, you know. And I think it shouldn't always be forgotten. There was a great article, again, probably years back now, actually, about the myth of the super user, that everyone was like us, that everyone had time and resources and, you know, intellectual ability and desire to keep switching, keep moving to a better social network, keeping in mind, you know, that you should not use Doodle or not use whatever and go and use the open source equivalent, you know. And I will hold my hand out and go that I don't have that amount of time, and sometimes I don't have the technical expertise, and largely I don't. Largely I use the easy real world alternatives, mainstream alternatives. So, you know, when you're applying these policies and when you're making these perfectly really good arguments about long-term risks and harms, but though not as long-term as existential risk, that we should consider the needs of the ordinary users, which does include quite a lot of people who aren't immediately threatened. You know, I mean, there is obviously the migrants, the poorer people, the people of color. There are the people for whom these things hit them every day, about the problems with the digital society, the problems with automated decision making, for example. And I absolutely understand that, and they understand it. But there are also an awful lot of people who balance convenience against kind of jam today as opposed to jam tomorrow, all the time, perhaps not consciously. And we have to take them into account as well when we're planning these things, when we're making policy, when we're selling policy, and when we're teaching it to our students. Perhaps while I'm on that hobby horse, okay, I will also say, sort of connectedly, that when I've been teaching my students, they've been lovely, you know. I mean, they've been precious little darlings, you know. And they say things like, well, you know, they wouldn't do that, would they? And I go, why? And they go, well, because it's not right, you know, it's not ethical. Never underestimate the ability, particularly of companies, to act in their own self-interest. Also people. But, you know, as I think Chris was sort of alluding, or Ian, you know, companies actually in many legal systems have duties to preserve shareholder value, increase shareholder value, you know, which is wonderfully parodied in Neil Stephenson's Cryptonomicon, most notably. You know, so follow the money. You know, when you're trying to work out what will happen, always think about the business models. I don't have to tell this to anyone here, but, you know, it is worth thinking about for students actually who are coming through where they do courses on public law and constitutions and values and human rights. And they begin to think that that's all people think about in the world, you know, because less and less of them do core private and commercial law as their main set of subjects, I think it's fair to say, in most universities. A recommendation, okay, in contrast to the things I've just said, is that people might be radicalized less by thinking about, you know, how bad, say, algorithms are for people of color, and more by the fact that their convenience is disappearing. And I must admit, the thing that's caught on the internet lately, and which has made me laugh a great deal, has been Cory Doctorow's doctrine of enshittification, you know, that everything is slowly getting more shit. You know, not just the British political system, not just Twitter, which I refuse to call X, but perhaps this is some kind of law of nature that eventually leads to the disappearance of the monolith unicorns, so they become extinct unicorns, right? Like extinct dinosaurs. So I don't have it to hand. I was looking just now, but go and Google Corydoktera with a W at the end, and then shittification, spelt like it sounds, and you will find a very, very interesting text.
Thank you very much, Lilian. And if I may ask you also to demonstrate a pile of books which you have somewhere in the office, authored or co-authored by yourself. Thank you. Ian?
I would recommend your students read broadly, as well as narrowly and in a focused way, which is obviously essential in specialized courses. So Eddie Corydoktera, as Lilian was saying, he has a new book coming out called The Internet Con. Cory's a wonderful communicator and thinker about a lot of these ideas. He's a famous science fiction author as well. So he brings in a lot of really interesting ideas about how technology might change and change our way of thinking about some of this. That links to what Lilian was saying, The Myth of the Super User is a great paper. And I don't think any of the three of us would argue with open source in itself and things like it will not save the world. The geek shall not inherit the earth, as people have put it otherwise. When I was a computer science PhD student, I loved playing with all of this open source, unwieldy software. I now am an out-and-out Apple fanboy. I have Apple everything. I've paid enormous amounts of money to Apple over the last 10 years as Lilian said, just the sheer convenience. And yes, I hate to say, Steve Jobs wasn't talking complete bullshit. The aesthetics. Apple devices are luxury fashion devices. They're no longer computers. That's why Apple is worth $3 trillion, much more than alongside what Chris was saying, that it's captured this enduring super monopoly rent for the future. Lilian with her device. I'm wearing my AirPods. I could not believe at the start of the pandemic lockdown I would ever have spent £250 on earphones, but if you're stuck at home, and even if you're not, here I am. And popular stuff like Cory's, but alongside that, I would say just one other recommendation, a book that I really enjoyed teaching in my course on internet regulation at Oxford. Actually, the first week was not about internet regulation. It was about 19th century internet regulation and earlier. And there are several good books on that theme, but one in particular was, I think it's called The Printing Press and the Making of Early Modern Europe. And it's about how the Gutenberg press, not being technologically deterministic, but had a very significant, very long-term impact on European society through the contributions it made to the Reformation, to the Enlightenment, and to the scientific revolution. And that's by a Cambridge historian. It's not even by a psychologist or computer science or one of these obviously adjacent fields to technology law. I think you can learn a great deal from science and technology studies, from history. Keep an open mind. Try to read one of these broader texts each week, as well as several narrow focus texts.
I've been very good and not interrupted the whole time, which, as they will tell you, is unprecedented. So can I just tag on there actually and recommend one of mine for that? Because that's what I thought you were going to say, which is The Victorian Internet, which is incredibly readable. You can read it on the toilet in the afternoon sort of thing. But also just for metaverse hype. It has this story in it about people getting married over the telegraph. And this was uber trendy, right? So there's nothing new under the sun, right? Then we saw people getting married in Second Life, and now of course we're hoping to see people getting married in the metaverse. So again, history, read history, or at least read stuff that happened a while ago and is now history, because I just call it my life.
It's a really important point that Tom makes in that book, and which is, there's a lot of literature on this in Australia. The time it took to get news back to London from Australia in 1869 was 6 weeks. In 1870, it was suddenly 6 hours, and then very quickly 6 minutes and 6 seconds. And that was because of the telegraph, the most revolutionary communications technology ever invented.
Amazing. Chris Marsden, Lilian Edwards, Ian Brown, thank you very much indeed for your time and for sharing with all of us these brilliant ideas.